Holding a temporary Australian visa does not automatically make you a foreign resident for tax purposes. Similarly, holding Australian permanent residency is not a guarantee that you are an Australian tax resident. Immigration status and tax residency are two distinct legal systems. The Department of Home Affairs manages your permission to stay, while the Australian Taxation Office determines your residency under tax law. This distinction carries significant financial weight. Your residency status determines your access to the tax-free threshold, whether you pay the Medicare levy, how your capital gains are taxed, and your obligations regarding foreign income. A visa label provides relevant evidence. It shows how long you can stay and your work conditions, but the visa subclass alone cannot answer the tax question. It is also a mistake to assume your status is settled because an employer selected resident on your payroll. A tax file number declaration is a reporting tool. It is not a binding residency determination from the ATO. Relying on an immigration label or a payroll checkbox is legally insufficient. These assumptions often lead to incorrect tax rates and unexpected debts. Australian tax law uses 3 distinct residency classifications. To avoid misreporting, you must correctly map your circumstances to one of these categories. An Australian resident for tax purposes generally declares income earned both in Australia and overseas. This category usually provides access to the standard tax-free threshold. While tax residents are often liable for the Medicare levy, this status does not automatically grant you eligibility for Medicare health benefits. The two systems operate independently. Foreign residents for tax purposes generally only declare Australian-sourced income, such as local wages or business earnings. They do not receive the standard tax-free threshold. It is a common misconception that holding a temporary visa automatically places you in this foreign resident category. The third category, temporary resident, is a technical tax law classification. It requires specific immigration and statutory conditions, and it provides significant tax concessions on many types of foreign income. Determining which category you occupy is the mandatory first step before you lodge a tax return or sign a withholding declaration. The ATO identifies 4 statutory tests to determine your status. Satisfying just one of these is enough to establish Australian tax residency. The primary assessment is the resides test. This looks at whether you reside in Australia according to the ordinary meaning of the word, focusing on your physical presence and the nature of your stay. The ATO examines your family ties, employment, assets, and social arrangements. Even a temporary work assignment can lead to tax residency if you establish a settled life here. The domicile test is the second assessment. Domicile is a legal concept, not a simple record of your current address or nationality. You can maintain an Australian domicile even while living abroad. If your domicile is in Australia, you are a resident, unless the ATO is satisfied your permanent place of abode is overseas. This involves weighing the durability of your connections in both countries. If your stated intentions conflict with your actual behavior, the ATO will prioritize your physical conduct. Ultimately, tax residency is about your behavioral center of gravity, not just your administrative status. Many people believe that spending 183 days in Australia makes them an automatic tax resident. This is a significant misunderstanding of the law. Under the 183-day test, you are treated as a resident if you are present for more than half the income year, unless your usual place of abode is overseas and you do not intend to take up residence in Australia. Conversely, spending fewer than 183 days in the country does not automatically make you a foreign resident. If you have established a settled life, you can be a resident under the resides test from day one. The final assessment, the Commonwealth Superannuation Test, applies only to specific government employees and their families. It is not triggered by having a standard commercial superannuation fund. No single metric, like a day count or a super account, is enough to settle your residency status. Your tax residency status can split midway through an income year. This often happens when you first arrive to establish a life in Australia or when you leave to settle permanently overseas. As a part-year resident, your tax obligations are divided. You may have a reduced tax-free threshold and different rules for foreign income and capital gains, depending on the date your residency changed. The date this change occurs is based on factual shifts in your living arrangements. It is not tied to the date your visa was granted or the day you passed the 183-day mark. You may also face dual residency, where 2 countries simultaneously claim you as a tax resident under their own laws. To resolve this, Australia uses tax treaties with many nations. These treaties include tiebreaker provisions that look at where you maintain a permanent home or a center of vital interests to determine which country has taxing rights. Crossing a border is rarely enough to end all tax obligations. Temporary absences and dual claims require a careful treaty analysis. To see how these rules apply in practice, we can look at 5 real-world examples where conduct overrides labels. Amira is on a temporary student visa, but has lived in the same apartment for a year, works part-time, and has joined local community groups. Her settled life makes her an Australian tax resident despite her temporary visa. Thomas is on a skilled worker visa, but is only here for a 4-month project, while his family remains in their home overseas. Because his life remains centered abroad, he is likely a foreign resident even though he is working in Australia. Lena is a permanent resident who accepts an indefinite job overseas and moves her family with her. By establishing a permanent life abroad, she stops being an Australian tax resident, even though her immigration status hasn't changed. Mateo spends 200 days in Australia, but moves constantly between temporary stays while keeping his home and ties overseas. Because his usual place of abode is outside Australia, he remains a foreign resident despite the 183-day rule. Nadia is an Australian tax resident who also meets the technical requirements of the temporary resident rules. This classification means she does not pay Australian tax on most of her foreign income and capital gains, unlike a standard resident. In every scenario, the specific facts of your life, measured against the statutory tests, are the only definitive way to determine your residency. Visa labels and day counts are not enough to confirm your tax status. You must treat your residency as a separate legal determination. Start by collecting your evidence: dates of travel, visa history, lease agreements, employment contracts, and records of your family's location and overseas assets. You should then use the ATO's official residency tool as an initial guide to see how the tests apply to your specific income year. Professional advice is essential if you have substantial foreign property, complex business interests, or face a dual residency conflict under a tax treaty. The frameworks discussed here were accurate as of the 24th of July, 2026. Because these rules are subject to change, you must verify your status for every year you earn income. Safely managing your Australian tax obligations requires looking past your immigration status and applying the residency test to your actual life.